Good morning. Hello, everyone. Welcome back to our weekly professional insights brought to you by the National Referral Network. And today we have the privilege of speaking with Rich Daniels, a seasoned general counsel attorney who works with business owners on a lot of different fronts, which we're going to talk about. One of the areas we're going to talk about specifically this morning is contracts, some of the pitfalls, some of the key elements that you as a business owner need to be looking for to protect your business moving forward. But before we jump into the conversation, as always, hit that like and subscribe button. Any questions you have, please leave it in the comments below. We'll get to them. The whole point of this conversation is to help you make better business decisions. And so with that said, let's jump into this. Good morning, Rich. How are you?
I'm fine, Mike. Thanks for having me.
Absolutely, buddy. It's been a while since we've talked and had you on the show. And I think the best question to kind of get things going, just kind of remind people is, Rich, what is a general counsel and what do you do?
Well, that's a loaded question. No. So think of a large corporation, and
Okay.
they have different departments, and one of those departments is the legal department, and the head of that legal department is the general counsel.
Okay.
Well, small, medium-sized businesses don't have the budget or the wherewithal to have that type of big legal department. So they usually only have maybe one attorney and a paralegal, or maybe even just one attorney, or there's some of these smaller businesses that don't even have an internal counsel. So
is a general counsel kind of like a general physician? I mean, it's not saying you're a jack of all trades, but you know enough to guide a company in a broad sense.
absolutely, that's a
Yeah.
perfect analogy. It's a corporate kind of generalist who helps the business owner with not only legal but strategic issues as well, working with all different departments, whether it's finance, operations, marketing, all different areas of the company, for not only their legal issues that may arise, but any strategy that comes about, because those strategies have some legal ramifications as they move forward.
And those strategies often come with contracts, which is really the focus of this conversation. And so, Rich, why is it crucial for business owners to review contracts before signing them?
Well, I think it's so crucial, and that's a really key word. You know, almost all businesses, no matter what type of business, services, products, whatever you do, you're signing a contract with someone else, a
Mhm.
vendor, a supplier, a business partner. Um, it's the crux of business is a contract, and in order to sign and properly understand the contract, you need to read through it or have someone such as myself help you advise on the various provisions that are contained in those contracts. If you don't know what you're signing, you could get yourself in trouble and could tie yourself to a long-term contract if there's no out. And you don't want to be breaching contracts, because that's just going to lead to litigation and take you away from your core business.
So there's a lot of legalese in contracts. Hereunto, therefore, with, I mean, all of these crazy words that nobody ever uses. So what are the common mistakes or some of the common mistakes that you see business owners make when they do review the contracts?
Well, there's not an underlying mistake that they make all the time, but
Okay.
they just need to know. For instance, I worked with one company that had no termination clause in their contract, so they signed a 5-year deal, and there was no way to get out of it before those 5 years were up. So
Gotcha.
if after a year they wanted to get out of the deal to work with someone else in that same area, a supplier or a vendor, they had no way to do it without breaching the contract. So there's just certain terms that you need to know. You need to know what you're entering into. You need to know you're getting into business with someone, and you need to know what your obligations and rights are and what the other party's obligations and rights are. And therefore you can, as long as you have that understanding going forward, you should have a good business relationship.
Okay, and we're going to get into the termination clause because that's one of the areas that I want to learn about, and I'm sure the viewers do too. But before we get into that, what are some of the other elements and clauses that a business owner needs to be aware of?
Well, there's other areas such as indemnification, which means, who, if there's a dispute, who is covering that dispute? If there's a third party that sues a business that I'm handling, is that liability going to be on my client or the party that they're working with? And so you have that language in the contract to determine who is at risk for those various disputes or obligations. Termination clauses, how you terminate a contract. And I guess as you want, we can talk into that a little further. And just what your rights are, your payment terms, how you're paying or being paid, what your obligations are in the service or product that you're providing. There's just a lot of areas, and if you're dealing with other agreements that are a license agreement, which is a contract, what the terms are, who owns the intellectual property that's being used as the license, and how can that be protected going forward in that relationship. So there's just a myriad of different issues that arise with contracts.
Rich, with the indemnity clause, and I'm kind of going off a little off script here because I see this, I've seen this in agreements. You and I have an agreement, and it states that if any dispute happens, it happens in my jurisdiction. And that jurisdiction could be, well, you're in California, I'm in Utah. So then how do you protect yourself against having to travel to Utah and kind of go to court or whatever that process is to protect yourself when we're in separate states?
Well, again, you get into the indemnification. So if we're in Utah and you are indemnifying me or my client, I may still have to travel to Utah at some point in time. However, you should be handling the case and paying for my attorney, my defense, everything going forward. And as part of that indemnification, you're indemnifying, you're protecting me or my client in that dispute. That's what the indemnification clause generally states.
So let's take a step back real quick. What is the definition of indemnity?
That's a good question.
Like, what does it mean?
It means that you are indemnifying. That means any liability that my client suffers, you're agreeing to take on that liability. That's the easiest way to describe it. So you're protecting my client as part of the contract. You're saying if there's a dispute out of our relationship that affects a third party and they sue me, I can come to you and say, hey, we have this indemnification clause. This is out of our relationship. You have to pay for my attorney, my defense, judgment if there is one, or a settlement.
Interesting. And so other than that, I mean, I know there's a lot to that, and then there's certain clauses, and these clauses are in the contract. I mean, they're headers, right? Indemnity clause, termination clause, payment clause. These should be headers in the agreement.
Correct.
But within the overall scope, things that may not be written buried on page 16, what is the overall potential risk and pitfalls that can arise if you don't review your contract?
Well, again, and I hate to be so repetitive, but one, you are right. All these different terms and these different provisions, they're all negotiated in the contract. So both parties should know what their obligations are and what their rights are. If you don't know what your obligations are, based on your example just now, if there's no indemnification and I get sued and I'm in California, but you're in Utah, I may have to come to Utah. I may have to get an attorney. I may have a lot of out-of-pocket expenses that I have to pay to defend myself in Utah. If I didn't know about that, or I didn't negotiate for a proper indemnification clause, I may be stuck with that. And that's a pitfall from not reading your agreement and understanding what your obligations are and what the benefit of the contract. It's very important that you read your contracts. And one of the things that you usually is in the contract as one of the bullet points that you talk about is the choice of law, where a case between you and I can be brought, whether it's in Utah and I agree to that jurisdiction, or I negotiate that California is the place where any dispute must be resolved. And therefore you have to come to California as opposed to me coming to Utah.
Understood. Now, Rich, a lot of these clauses, I mean, indemnification, termination, payment, well, maybe not payment, but some of these are farther down in the agreement. Most agreements at the very top have a scope of service. And this is kind of where the money's at, right?
Right.
And so I know we kind of went from the bottom up here, but you and I've talked about this. Most agreements and a lot of companies do not clearly define what the scope of service is. What am I paying for? What are you delivering? And so can you go into a little bit about the importance of the scope of service and being clear with that?
Absolutely. So So the statement of work, and this is whoever's obligation it is, what the scope of services are, or the statement of work, or what is to be provided. It has to be clear, because that leads to a lot of disputes. You say, oh, well, you were supposed to provide this type of specification on a product. Well, if that's not specified in the scope of work, then you get into a dispute. You say, well, I thought it was this. And I say, well, I thought you thought it was X and I thought it was Y. I mean, that's ripe for litigation. That's something you want to avoid. So you have to be very clear on what you're providing, what you're obligated to provide.
I don't want to pick on marketers, Rich, but I think this is a great example. Is marketers will, you have an ad spend, and the scope is they're going to put together Google ad for their ad campaigns, or cost per click, or whatever the ad campaign is.
Right.
But they rarely ever provide an ROI. They rarely put on there, hey, if you do this, you're going to get 150 clicks, or you're going to get 150 leads. So then how come more marketing companies aren't, I don't want to say sued, but why are there not more disputes with marketing companies? Because they are so vague in what they do.
Understood. Well, there's certain things that they can't guarantee unless they're doing something with their marketing that they can guarantee you're going to get such a response. But it's very hard for them to guarantee. And the reason they don't put those in agreements is because they would be sued, because 9 times out of 10, they're not going to make what they guarantee.
Gotcha.
So you have to be really careful what you put in your agreement. You want to be obligated to provide certain services, but you shouldn't be guaranteeing any results in any type of contract, whether it's marketing, products, or whatever. And so you really need to be careful how you define your scope of services or your statement of work when you're doing work between different businesses.
So if our agreement is I'm going to provide 1,000 widgets at X price, now that's a very specific scope. Is that something that should be in an agreement?
100%. If you have a certain number of products at a certain price, you definitely need to have that in the agreement, because the price could change. And if you don't have a price set, or for some reason you can't produce those 1,000 widgets, say, hell, here's 900 widgets. Well, the contract said 1,000. Well, we had a breakdown in our production. Well, sorry, that's not a good enough answer, because you are obligated to provide 1,000 widgets. And if the price changes, you want to lock in that price, because at the time you make the contract, that's the price you're comfortable with based on all your evaluation and your forecasting and your budgeting. You know what the price is. So if I'm putting that product for sale through my business, I know what I can make and what my margins are going to be. It's a domino effect, right? It goes all the way through to the ultimate consumer.
And if by chance, as a supplier, and it doesn't matter if I'm a CPA or widgets, as a supplier, if the terms change, if something happens, I'm unable to fulfill that obligation, that scope in the time allotted, is it, obviously you want to communicate that. Do you make an amendment to the agreement? What are the steps to do that?
You can. So it's very important. Just say you're only going to be able to make the 900 widgets. Maybe what you do is you let the other party know, and you say, okay, we can only do 900 widgets. We had a breakdown. We're not going to make that time. We'll give you a price reduction because of that, or something like that. And then you do an amendment that's written in, and usually contracts have some language in there that any amendment has to be signed by both parties in writing, and therefore both parties understand what the change or the amendment or modification to the contract is. And therefore you can move forward doing business. You don't want to just breach a contract and just leave it open, because that's where the dispute arises, and that's where the business relationship breaks down.
Do you need an attorney, Rich? And I understand that you review these and that's part of your scope, right? But for you and I to do an amendment, let's say, do we actually need an attorney to draft that amendment? Can we just agree upon it as adults?
You probably can. If as long as you've had someone look at the agreement, initially. If you're just making a minor change to the agreement, you probably don't need an attorney, because you know your business, I know my business. So why why having it just to do an amendment? It's probably very short and very basic, and there's no legalese involved in that for the most part. You could probably do that without an attorney, as long as you just set it forth in a formal document and signed by both parties. You should be fine with just an amendment without an attorney.
So at what point should a business owner seek the advice of a professional like yourself when drafting or reviewing contracts?
I think from day one, when you're negotiating the contracts,
Okay.
because it might be too late when you get a contract from another party. Here's our contract, sign it, or we're not going to do business. At that point, it may be too late, and you may lose that business. So it's important early on to get an attorney involved, so you know what your expectations are, you know what you're hoping to achieve by entering into this business relationship, and therefore you can have that attorney help you negotiate the various terms you need to be in that contract before someone just slides a paper across the table and says, sign here.
Yeah.
So I think negotiation, when you're starting starting those negotiations and starting to form the contract is when the attorney should be involved.
And so walk us through, and I'm sure this is this could be a discussion, a topic all in and of itself, right? But walk us through kind of a typical contract review.
So usually when I get involved, I'll meet with the business owner, my client, and say, what are you hoping to achieve by this contract? And so we kind of set our own terms. We'll set all the terms: price, timing, product, specifications. What law do you want to govern this agreement, whether it's California or Utah? Is there an indemnification clause? Is that something the industry usually recognizes, in that type of contract as indemnification? There's just a multitude of terms. So I go through that with my client, and then we reach out to the other side. And depending on how the business works, like if you're dealing with a very large company, say like you're buying products or you want to sell products through Walmart, Walmart has standard contracts,
Yeah.
and they're the ones who are going to submit the contract to you and say, here's our contract. Yeah, you can make some changes, but we're Walmart, so you have to make only minor changes. But if it's businesses that are more on the same level and the same size, you'll work with the other party and determine who's going to start with the first draft. And then you start the draft, and then you start drafting and negotiating terms, and until both sides have what they feel is the right terms and conditions of each of those contracts, and then you can go ahead and sign it.
So Rich, let's jump into Walmart real quick. And it's not just Walmart. Costco, I hear, is the same way.
Costco, Best Buy, all the big units.
If you don't review that contract, and there have been companies, small companies, that have just been elated that they've been able to get into these big box stores, but if they're not able to perform, it's really on them. And there have been companies that have had to go bankrupt because they haven't been able to fulfill. So correct me if I'm wrong, but this is where it's extremely important that just because you think you're getting into Walmart or Costco or any of these box stores doesn't necessarily mean it's a good business decision because of these contracts that are not being reviewed. Is that kind of an accurate statement?
That's very well said. And I've had experience with a number of these big box companies, and what you need to do is you need to look at the agreement, know what you're getting into. Yep. That's really the key. Know what you're getting into, because they won't move on many of their terms. I've had some things, and I've had some dealings with, and they don't only have a general counsel, they have scores of attorneys working for them. Yep. and who deal with various companies on these contracts. And that's all they do all day long is negotiate these contracts. And like you said, you could get yourself in a lot of trouble if you're not sure what you're entering into when you do a business with a Costco or a Walmart or a Best Buy.
Yeah. I mean, I've heard horrible stories. And then other businesses turn them down, and their colleagues are like, oh my gosh, why would you do that? And they're like, have you seen the terms? Like, it could bankrupt me if I do this, and it goes sideways. I could be gone.
And not only that, places like Costco, where once you're out, once you lose, if you fail on one of your contracts, you'll almost never get back into that business. Yeah. So it's an ongoing thing. And like you said, it's kind of prestigious to get into a Costco, but once you lose that, you'll be out for good for the most part.
Yep. And so wrapping up here, Rich, what are your top 3 tips for business owners to protect themselves when going through this process and entering into contracts with partners or strategic partners, whatever it may be?
So first of all, know what you want out of a contract. Know what you want out of a business relationship. I try and tell my clients that you're getting into a business relationship with someone a year, 2, 3, 5 years, whatever it is, And it's kind of like a marriage. You want to know what you're getting into. So that's why it's important to know what you want to get out of it and what you're willing to give up to go forward with that relationship. So that's the first thing. Secondly, read the contracts. Read the contracts and know what I had a client, and I think I mentioned this to one of our previous. I have a client who said, "Oh yeah, we have contracts in all different areas with a lot of different organizations. No one's really looked at them. Maybe I should have you take a look at them." And I was like, "Yeah, that might be a good idea because these are already signed contracts, so they may be required to follow through with them, but there could be some things in there that they're not aware of."
Mhm.
And just, and they don't have to use an attorney too extensively, but have an attorney look at your final contract before you sign it, because they may point out something, whether it's legalese or not, that you weren't aware of, or maybe you didn't understand the provision, but there's some businesses say, "Ah, well, that's just one provision. It's not going to hold me in any," and that could be the key provision in your contract that causes a dispute or causes you to lose business.
Interesting. Well, Rich, I certainly appreciate the time. Thank you so much, as always. If you guys have any questions, please leave them in the comments. We provide this content based off of your questions, and specifically, we'll get them to Rich. We'll get them answered. But hit that like and subscribe button. Follow Rich. His information is below in the description. Thank you, Rich. Thank you, everybody, for being here. We'll see you next.